You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 78, Invalidating Someone Else's Patent Part 2, Inter-Parties Reviews. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's DIAMENT, patentlaw.com, or call me at 424-281-0162. In the last episode, I talked about one kind of procedure you can use with the Patent Office to try to invalidate someone else's patent, called an ex parte reexamination. In this episode, I'm going to talk about another kind of procedure you can use, which is called an inter-parties review. Now, you might come across something called an inter-parties reexamination. It's confusing because there's inter-parties review and inter-parties reexamination. The one I'm not covering is inter-parties reexamination, and that's because these were only for patents that were filed between November 29th, 1999 and September 15th, 2012. So any patent filed since that 2012 date, you can't use that procedure anymore, so it's becoming less and less frequent. Inter-parties reviews are for patents that were filed starting September 16th, 2012. They're a lot more expensive to file. It will currently cost $30,000, $500 just to the Patent Office, and that doesn't include attorney's fees. Now, remember I said that for ex parte re-exam, it usually costs around $3,000, but it can vary depending on your business side. So why would you want to pay more than $25,000 more for an inter-parties review? The main reason is that you have more back and forth with the Patent Office. Remember I said for an ex parte re-exam, once you file your initial papers with the Patent Office, that's usually it. Your interaction is done. You can't keep arguing points later to convince the Patent Office that you're right. With an inter-parties review, it's more like a mini trial, and you get to have a lot more interaction with the Patent Office. A lot of things are the same as the ex parte re-examination. You're only allowed to request that the patent be invalidated based on lack of novelty or obviousness. The timeline's a little bit different for inter-parties review. For the ex parte re-exam, you can petition while the patent is enforceable. For inter-parties review, for current patents, under the filing system we have now, you have to wait at least 9 months that have passed before you file your petition to invalidate someone else's patent using the inter-parties review. If 9 months haven't passed yet, and you don't do the ex parte re-examination, there is another procedure, which I'll talk about in the next episode, called a post-grant review. Now, in order to get your petition granted, there's a slightly different standard. In the ex parte review, you have to raise a substantial new question of patentability, which is what a reasonable examiner would think is important to determine the patentability of the claims. For the inter-parties review, you have to show a reasonable likelihood that the petitioner, which is you, would prevail with respect to at least one challenge claim. Now, in practice, I'm not sure how much difference that's going to make, but technically there's a difference on how likely you will prevail, and the way I read it is that the inter-parties review has a higher standard. So in order to get to the next phase of the inter-parties review, you have to show a little bit more about the likelihood that the patent would be found invalid. Also, the person examining is different. In an ex parte re-examination, you have a single examiner doing the examination. In an inter-parties review, you have 3 or more members of a panel. Now, remember how I said this is like a mini trial. In an inter-parties review, you can have discovery, which means you can request the patent owner to provide documents. You can also have an oral hearing. You can have expert witnesses, examination of witnesses, cross-examination. You can't have these things in an ex parte review. One thing in an ex parte review that I mentioned is that if you wanted someone else's patent, you can request it anonymously. In an inter-parties review, you can't request it anonymously. You have to say who you are. So how does this work in practice if you want to use this procedure to invalidate someone's patent? You file a petition with the Patent and Trademark Office, and in it you say who you are and essentially why you think at least one claim is invalid, and you could put in exhibits and other things showing the Patent Office that the claims are either not novel or they're obvious. You have to serve the petition on the owner of the patent. The patent owner then can do a preliminary response to your petition. After the preliminary response, the Patent Board is going to determine whether there's sufficient grounds to go on to the next step by making a decision whether the inter-parties review is instituted, which is whether there's a reasonable likelihood that at least one of the claims is not valid. Now, if your petition isn't granted, you get about half of your $30,500 back. So in the end, you're paying about $15,000 to the Patent Office. And when I say not granted, it means you're not even getting to the the mini trial phase. You could still lose and you wouldn't get your money back, but as soon as it goes to that mini trial phase, when your petition is granted, that's when all of your money is going to be gone and there's no refund. The cost can vary a little bit depending on how many claims you have, so these are just kind of rough numbers. If the inter-parties review is granted, there's going to be a scheduling guideline that has all these dates that certain things must happen, and it sets the guidelines for the review. The patent owner can amend some of the claims in some circumstances, or maybe make some of the claims that are, questionably patentable and the claims that have more of a chance of being patentable. There are going to be deadlines for the patent owner's response to the petition, motions to amend, the date for you to reply to the patent owner's responses, dates that you have to request to exclude evidence and request oral arguments, dates for opposing the motion to exclude evidence, dates to reply to opposing counsel, and all sorts of things. So you see, this really looks like a trial, but instead of using the regular court system, you're using the patent office. Now, you can just use the regular courts to invalidate someone's patents too, but that's going to be much more expensive, and I might cover that in a later episode. But I want this podcast to be focused on your interaction with the patent office itself and not the court system. The patent office is cheaper, and it's more a streamlined version. And you also get a panel of people that are supposed to have more expertise in technology, the technology that you're challenging. If you go to a regular court judge, there's a good chance that the judge has absolutely no knowledge of technology whatsoever. After you go through all this mini trial, in theory, you should get a decision within 1 year of when your petition for inter-parties review is granted, and that might be about 6 months after you did your initial filing. So you can expect a decision hopefully within 1.5 years of your initial filing, which is also a lot quicker than if you use the court system. Now, in terms of cost, I mentioned the $30,500 to the patent office, but that doesn't include attorney's fees, and I've seen one estimate of inter-parties review costing approximately between $100,000 and $600,000 once you take into account attorney's fees, expert witnesses, discovery. So it's not cheap, but it's cheaper than trying to do this in court, which would probably be over $1 million. That's the basics for inter-parties reviews. Obviously, there's all kinds of details I'm leaving out. It's not something you should try to do yourself, but if you're interested in invalidating someone else's patent and you talk to a patent attorney, hopefully I've given you enough information so that you can ask the questions of what kind of procedure you're going to use and at least why the patent attorney is leaning to one way or the other. And if you want help with your patent applications, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.